since we're at the essentially beginning of the year, kind of starting over just with the basics. And so what is estate planning? So I'm going to share a few slides I have just because I know that some people are more visual. So if you give me a moment, I will share my screen. So just as I mentioned, legacy conversations, it's estate planning. I like to think of it as legacy planning because there are components that apply while we are alive, and then there's things that we want to take care of once we've passed away. So the word legacy, it's a gift by will, especially of money or other personal property. It's something that's transmitted by or received from an ancestor or predecessor from the past. Excuse me, the legacy of the ancient philosophers. So I always like to look up definitions, but I would say the Latavia translation or definition of uh, of legacy is it's kind of not so much about what you did, but how you remembered, what people remember you about or for. And so there are components of legacy. And so that's where it's like, okay, how do you want to be remembered? What do you want to leave, whether it be something tangible, if it is a mindset, a character trait? Those are all things that I take into consideration when I'm working with someone about developing their legacy plan. So what is estate planning? I'm learning or realizing that a lot of times people don't necessarily know what that word is or means. And if you're like me, growing up, I thought estate planning, that was for something that only very wealthy white people did, to be completely honest. Or you had to have all of this land or, an estate is acres and acres upon land. And so if you had that, then you did an estate plan. Thankfully, I learned different, and I want to make sure that everyone else understands that if you are alive, you have a right to plan. You have an estate. There are things that you need to take into account and plan for. So estate planning is literally just the action of arranging your life before death. And doing so minimizes the effects it says here gifts of, the effects of gift estate, generations, there's the taxes and all those things, but really it's, for me, at the heart of it is how can we minimize the stress and anxiety and fighting that comes when someone passes away. When someone passes, there's going to be grief, there's going to be sadness, there's going to be it's going to be a difficult time. But what are some things that we can do while we are alive to make that just a little more bearable, a little less stressful for our loved ones after we have passed away? So I don't know if you ever heard this. I heard this often growing up. If you fail to plan, you plan to fail. And so that is where having a plan comes into place. So I like to split it up into there's life planning and legacy planning. And so there's life documents. And depending on where you live, it may be called an advanced medical directive or a healthcare power of attorney. But essentially it provides instructions for who you want to be the person making decisions in the event of an illness or incapacitation, whether it be temporary or a permanent or long-term illness. Who is the person that you want to be your healthcare agent, making those decisions and for you? And then also, so you can kind of do it as, hey, I'm just designating one person, the person that I want to make these decisions. I trust them to make the right choices for me. Or you can go further and say, hey, this is the person that I want to make the decisions. And then also, these are the decisions I want you to make. Like, I have already decided how I would like my care to be, or oftentimes this comes up of, do they have a DNR, a do not resuscitate? You can make that decision or that determination in this document. It also covers in the event of an end-stage illness or terminal illness. Do you want to be, do you want them to do any and everything to keep you alive, or do you not want to, or kind of to what extent do you want your care to be and how long? So that's what that document covers. And great, it's great to have this document, but it's even more important to make sure that you have a conversation with your loved ones about what your wishes and desires are. You definitely want to let the person you're designating as your healthcare agent know that you have designated them and that they know that they have been chosen, also that they know where the document is. You want to make sure that your medical providers know that you have one, and if they don't have a copy, that they know where to get it. Um, because if those things happen and you become incapacitated, you are no longer able to designate someone. It would have to be either there's a default to next of kin, or depending on the situation, the family members or loved ones would have to go through the court to be appointed as a guardian. And that's a much more extensive and expensive process. You also have to get the court involved. The second document that I want to touch on in terms of life planning is a power of attorney. The power of attorney is another document that allows you to give someone authority to make decisions, not just for you, but in essence, in place of you. They would be, depending on the amount of authority you grant them, or what, if you don't put any limitations on it, it gives them the power and authority to make decisions, to sign documents, to do things as if they were you. And so with anything, you don't want to make these decisions lightly, but definitely with the power of attorney, because you can write it or you can execute it in the way that it becomes effective as soon as it's signed, or you can create some conditions for when it becomes effective, and that's called springing. But either way, you want to make sure that it's someone that you trust, and to essentially to make sure that they're looking out for your best interest as well as the best interest of your family and those you may leave behind when you pass away. Because there are horror stories of someone gave a child a power of attorney or a friend a power of attorney, and then they abused that power and opened up credit cards or signed contracts, and or just kind of essentially wiped their bank account out, and there wasn't anything they could do about it because you gave this person the authority. But it is similar to the Advanced Medical Directive or Healthcare Power of Attorney. It is an important document to have, because if something were to happen where you're not able to make those decisions for yourself, or maybe something where you're not as mobile, you become immobile and you're not able to get around. Oftentimes we see these come into a place as with where as individuals are getting older, they have their children become the power of attorney so that their children can help them in making decisions or paying bills or doing things with their bank account. Because once again, with this one, you can only give or grant someone that power of authority or of attorney while you are alive and uh, of sound mind. It's same rules in terms of as if you were entering to a contract. So if something happened to where you were deemed to be incapacitated or incompetent, for whether it's temporary or long term, you would not be able to grant someone a power of attorney, and then we'd be back to where you need to seek guardianship. Okay. So I'm going to transition and I want to pause just to see if we have any questions. Okay, I'm not seeing any questions. And as I mentioned, this is designed to be a conversation. So if you have questions, please come off mute and share your questions, or you can put it in the chat. Um, but I do want to also, like I said, it's a matter of giving information, but also a conversation. So when we're talking about, like I said, it was just about the life portion, the life planning document. So once we're talking about documents that will go into effect once you've passed away, the most common I think that people have heard of or are familiar with is a will. And so a will it's a written document. Essentially, I like to say the will is where you put out your instructions for what you want to happen after you pass away. Um, whether you want to be buried or cremated, if you want to put details about your burial, your funeral, those types of things. Also, you designate who you want to be responsible for making sure your wishes are carried out. If you state who your family members are or the people that you want to leave items to. You identify those people. You identify any property, whether that's personal property or real property that you own, and who you want it to go to. Items, there's items in the house, or if you have collections, it's where you essentially lay out all of the wishes that you have, who you want to receive or inherit, who gets what, how much. Also, if there are minor children or if there are other family members or even pets, that you are responsible for, you also identify who you want to be, who it is that you want to take care of them when you pass, and whether any provisions you have left to care for those children, pets, other family members. And so for a will to be valid, you have to be at least 18 years old and have capacity or be of sound mind to enter into a contract. And most states require two witnesses. And one thing with the witnesses, there are some states that explicitly state who cannot be a witness, but just a good practice is you want to make sure that the people you have signing as your witnesses are not those who will inherit, who are listed or stand to inherit in your will. And like I said, it's not always a matter of that it's prohibited, but that is helpful in the event that someone were to challenge the will later. If someone challenges to say, hey, I don't think that's what they really meant. I think someone, there was some undue influence when they were drafting this. If, let's say, you left something to one child but not the other, and the child that you're leaving something to also signed as a witness, that kind of gives a little bit more strength to the argument that there may have been undue influence. It doesn't automatically mean that that's the case, but if you just make sure that you have neutral witnesses, that strengthens the argument that, hey, this person made this decision, they were of sound mind, of no influence or coercion from anyone. This is what their wishes were, theirs and theirs alone. And I want to point that out. I didn't mention this for the power of attorney and the advanced medical directive. Those both need to be signed and witnessed by two people with the, I would say, same rule of thumb. You want to try to have people who are not, you don't want your designated agent or your power of attorney signing as a witness. With the advanced medical directive, you can't have more than one of the agents sign as a witness. Otherwise, it's not valid. And for the power of attorney, most states require that you also have it notarized in addition to it being signed by two witnesses. So another tool that I will touch on a little bit, go into more detail in some other sessions, but I do want to make sure that I just touch on it, that there's the will. That's the most common. Another tool for addressing how you want to handle things while you are alive, as well as once you've passed away, is a trust. There's definitely been more conversation about trust, what they are, and the role that they play and how beneficial they can be. I've seen that conversation increase in recent years. So that's something else to keep in mind. And like I said, the trust, there are different types. Like I said, I'll touch on it a little more later, but I just want to at least bring it up. But before we get to that, you might be wondering, like, okay, I know I need to do this, and you're saying we should have conversations, but how do we do it? As you see here, I mentioned earlier, talking about death it's not ideal, it's not fun. There's those that believe if I talk about it, it's gonna happen. Or hey, if we just don't talk about it, everything's fine. I don't want to think about it. I'll just figure it out when it happens. Or I think there's this other misconception that we have time. I got time. I'll deal with that later. I'll deal with that next year. I've got time to deal with it. And we don't know how much time we have. I think one of the, things that we know is we are going to die. We don't know when, we don't know how, or what the circumstances will be. So let's not fool ourselves into thinking that we have an infinite amount of time to figure it out. So when it comes to having the conversation, the easiest way is just to rip the Band-Aid off and to just start. And you don't feel like you have to have got to cover everything in one conversation. It's just little bits and pieces I always say, start with having it with yourself. Like, hey, what do I want? Have I thought about if something were to happen to me, who would I want making my decisions? Who do I trust to make these decisions? And not just who do I trust, but who do I believe is also capable of handling it? That it won't become just some completely other stressor for them. But someone who also I know they know me, they know what I want, they know what I need, they know what's important to me, and they are going to take all of those things into consideration when making these decisions for me, whether it be while I'm alive or once I've passed away. They're going to make sure that, either they do what's needed or they're going to seek out a professional who can help them make sure that my wishes are carried out and that those I want to be cared for are cared for. Okay. So when we're talking about how to prepare, like I said, you're having that conversation with yourself or with your other ones. I always start with identifying the goals. What are your goals? What are your desires? Figure then who are your loved ones? Do you have any minor children or even adult children with special needs? Are there other people in your family that you have been the caretaker for, you're providing for them? You want to make sure that as close to you can keep them as close to possible of the standard of living and standard of care that they've become accustomed to while you were alive, even when you pass away. Identifying your assets. What do you want to be buried or cremated? Do you want your body donated to science? Do you want to be an organ donor? Do you not want to be? Do you want to leave things to charitable organizations? I think it's Warren Buffett who has said, he doesn't plan on leaving any of his wealth to his children. He plans to donate, everything is going to be left to various charities or other organizations, which you can do. You don't have to leave things, you don't have to leave everything to your children. But those are things to think about. Do you have insurance policies? Do you have life insurance? Do you have retirement accounts or investments accounts? Um, those types of things, like identifying all of those things so you understand what do I have? What do I have control over? What kind of resources are available to me while I'm alive? And then what are things that I could potentially pass on when I pass away? Um, Another misconception that I've heard or myth is that, oh, when I die, it'll just go to my, if I'm married, it's just gonna all go to my spouse. Or if I have children, it's all gonna go to my children. And in some cases, that may be the case, but one thing I didn't go into detail here before is the reason it is important to make a plan and to write it down is because every state has developed a set of laws. It's called intestate succession or the Intestate Succession Act. And essentially that means if you die without a will or a trust or some type of estate plan in place, the state has already decided how things are going to be distributed based on what they think most would want. And in some cases, it might work out to where that aligns with what you want, but not always the case, especially if it's a matter of you really, you might have estranged children, or if you don't have children, things are going, and you have siblings, and you're not married, then those things are going to go to your siblings. Uh, Something similar happened with Prince when he passed away, which I'm still confused, hurt, and shocked by that he did not have a will. But in his case, he did not have children. He was not married. And so his estate was handled by Intestate Succession Act of the state that he was living in. And essentially, it was to be dispersed amongst his siblings. They were not all in agreement about who should get what or how, whether someone be entitled to something. And so it was a battle between the siblings, the IRS, and various other entities, battling out who should get what and who's entitled to what. And it took millions of dollars in taxes and just years of litigation to sort that out. And so those are things you want to avoid. So like I said, that's something to keep in mind when a person dies. But other things, whether there is a will or not, some of the things that you need to keep in mind is you want to get in contact with the funeral home, making sure that the body is picked up and then you get a death certificate because you will need that uh, to move forward in terms of handling the distribution of their estate. And this is regardless of if there's a will, a trust, or not. If the person did have life insurance, you want to make sure you contact the life insurance company to find out what their process is for distributing the funds. Something else to keep in mind with life insurance, it doesn't matter if you say you want proceeds of your life insurance to go to a specific person in your will or in your trust. The life insurance, so anything, just kind of a rule of thumb, anything that allows you to designate a beneficiary, that is going to be distributed outside of a will or a trust. So life insurance. If you have, and I've seen this come up where there's people who have remarried. If you had your first spouse listed as a beneficiary and then you're divorced and you remarry, you want to make sure that you go back and update your beneficiary and remove your previous spouse. Because if you don't remove them when you pass, that life insurance company is going to distribute the proceeds to whomever is listed as the beneficiary at the time of your passing. They do not care. I'm sure they'll feel bad. They might have a little empathy, but they're going to distribute it to that person because contractually that's what they're obligated to do. Same with the retirement account or investment account. So you want to make sure that you keep that updated, um, because that's who it's going to go to. So even if you did not want the money to go to, let's say you had listed one of your children, but now you're estranged, you don't want them to, or you don't feel like they need it anymore. If you don't remove their name, then that is who it's going to go to. Something else to keep in mind is if you list minors as beneficiaries, you want to make sure that you also identify on there that you want it to be left to the guardian of the minor, because otherwise the company is not going to release funds to a minor, and whomever is the executor of your estate or personal representative, depending on where you live, they will then have to petition the court to be essentially appointed as guardian of that child for the purpose of receiving the life insurance proceeds. And I want to pause. I know that I feel like I'm going through these things pretty quickly and I'm covering a lot of things. So I want you to know this is nuanced. There are multiple layers. And so the goal today is just to give you an overview. Over the course of the next sessions, we will focus on different components of this and go in more detail. I will also have other colleagues or professionals to come in to be able to speak to some more of the details of these different components. But like I said, today the goal is just to provide an overview. Okay, so I touched on pensions, retirement plans. Same way, you want to make sure that the beneficiaries are updated. You contact those respective organizations to find out what their process is. And you want to make sure once you get that death certificate, you get at least 10 copies of that certificate, because you're going to need to provide that death certificate to multiple entities to verify that the person has passed away and that you are the person entitled to receive proceeds. Okay. I touched on this already a bit. Essentially, when someone dies, you have to go through the probate process. And this is where I've heard a lot more chatter, I've seen a lot more videos and things on social media, people talking about you need to do things to avoid probate. And yes, probate can be it's a necessary evil in some respects. So it's a process that you have. Essentially, probate is the process for distributing the person's assets when they die. And so you will go through probate whether the person had a will or did not have a will. And essentially, you're letting the court know, hey, this person passed away and we want to now distribute their assets. And so you have to open the estate. And it is done through the court. Each state has a different requirement in terms of what the fees are for the estates. Oftentimes, the fee that you pay for is going to be dependent upon the size of the estate. And so a lot of states have kind of broken it down to where there's a small estate, regular estate, or large estate. And if it's a small estate, which usually it covers, if there's someone who passed without a house, or the house was valued under a certain amount, then it might be probated as a small estate, and there'll be a very minimal fee that has to be paid. And depending on what's going on, you might be able to get that fee waived. But there is a process for going through that. And then if you have, let's say the person had a trust, you won't need to go through the probate process, the court probate process, but there is still a period of, kind of an administrative period where you're going through and making sure that you're distributing assets as instructed in the trust. There, hopefully if the trust was funded properly and set up correctly, that will be minimal, but there is still some administrative pieces that are required even with the trust. Excuse me. Okay. So like I said, we've covered a lot, but just some things to remember And I want to say that I've touched on all of these at once, but just some reminders of things, updating beneficiaries when there's life changes. I like to say, think of it as if with your job, you have that open enrollment period for health ed coverage. Anytime there's, they do it annually, or if there's a major life event, you want to review it. So any major life events, make sure if you have these documents in place already that you're reviewing them to make sure, hey, does this still meet or accomplish the goals that I have? Because what my goals are, even for myself, when I first started doing this and I was putting together my will or looking at my things, I was single. It was just me. And so what my goals were at that time are different than what they are now, where I have a child. So I'm looking at things differently. There's other things that I need to factor in. You want to make sure that you're, like I said, checking your documents anytime there are life or financial changes, um, making sure that the name or the title for cars or deeds on property are accurate. Making sure you're letting the people know, like, hey, I created my estate plan or I created my legacy plan. This is what my goals are. This is where it is. Um, Most states or counties do allow with your will, you can register it with the county. So that way, the original is with the county. So when you pass, you want to make sure if you do that, you let your loved ones know so that they know, okay, she did have a will or he did have a will, and this is where it is. If you if you have a safe deposit box where you keep all of your important documents, you want to make sure that someone else knows that and that you've listed them as someone who's able to access that safety deposit box. Because if it's there and they can't access it, then the court is going to treat it as though you passed without a will. So you would definitely, I would hate for you to do all of this, to take the time to be proactive and plan and have it in place, and then no one knows about it or knows that it exists. And then we're kind of back to square one. And I'll bring up Aretha Franklin because this is essentially what happened with her. She passed in 2018. I think as recent as like 2023, they were still her estate was still open because they were still sorting things out. And over the course of those years, there was, she didn't have a will, or there were multiple versions of wills that were found, but they weren't valid. And it wasn't until I want to say, I think in 23, that they actually found a valid will. But at that point, thousands, millions of dollars had already been spent in time in court and lawsuits and just disputes between her children, um, the record labels, things are like of who was entitled. Of course, the IRS got their money. But like I said, that's just an example of what could happen if you don't uh if you do plan, but you don't have the conversation and don't make it clear where the documents are and who's supposed to have what. Um, just some other things to think about, especially in the age of social media. Is there someone who I know a lot of the different sites now have it where you can set up list of, if something were to happen, this is who can have access. Do you want your account to continue? Do you want it to be stopped? With making sure someone has access to, your email, your bank accounts, anything where there is a login information, where are those things kept so that someone can access it to stop. If there are reoccurring charges, if you have things on auto pay, making sure that someone has access to that so they know to go in and stop those things so that think money's not being spent unnecessarily, because it might take, well, depending on who it is, they might not know or even care that it's being paid and the person has passed away, or it might take them a while to realize that. Um, Once again, back to your burial, do you want to be buried or you want to be cremated? If you want to have a service, you can say how you want your service to be handled. I know someone who she said that's going to be like her funeral will be the last big event that she plans, and so she already has the details laid out of how she wants it to be done. You can specify what you want to wear, who you want, what funeral home you want it to be, where you want to be buried. Those are things that you can prepare for ahead of time. You can even, you can purchase a burial plot. You can prepay for your funeral if you want. Even with terms of the obituary, like what do you want your obituary to look like? What do you want to be included? I think it was I think it was Senator McCain that they said when he had included in his will or his wishes that of who he did not want to attend his funeral. So he had gotten, into details about that. So those are just some examples of how detailed you can be. Um, because like I said, if it's not documented, they're not legally enforceable. So reiterating, just like I said, the goals is to reduce stress and anxiety while you're alive, and then you want to reduce the stress and anxiety for loved ones after you pass away. It minimizes cost, it minimizes time and taxes when you do make your plan. Okay, so like I said, that is a very quick overview of estate planning, some of the basics. I'm going to pause to see if there are any questions. Any questions? But I do want to thank you all for either attending live or watching this first installment of Legacy Conversations for this year. As I mentioned, I will be doing this once a month. It will likely be the third Saturday of each month here through Zoom, or you can watch live on Facebook. If you're not able to join live, um, the sessions are recorded and they will be made available on the LA Legal Solutions YouTube page for viewing later. So today's session, as well as all of those from last year, will be available on YouTube. So that way, if it's you just want to have a replay to hear it, or, like I said, in terms of having that conversation, if you're not necessarily comfortable bringing it up with friends or loved ones, you can send them a video and say, hey, check this out. And like I said, each month we will focus on a different topic and go into more detail on some of the components of that and break it down. Like I said, if you have questions in between, please feel free you can message me on social media, on Facebook and Instagram. It's LA Legal Solutions, and that solutions is spelled with a Z at the end. You can send questions or you can send them via email at info@lalegalsolutions.com, and I will review those and then can address them in the next session. But I thank you again for joining and for watching. Like I said, the goal is to help one is to provide information to educate and to encourage conversation, to facilitate dialogue, so that we can be better equipped to take care of ourselves, to protect our interests and our legacies for ourselves as well as for our loved ones. But thank you, and you all have a great day.